Okay, the judicial system and its influence on tax law. When a taxpayer has an issue with a tax treaty, a tax law as codified in the form of the Internal Revenue Code, a Treasury regulation or interpretative, an IRS pronouncement, or a judicial interpretation or decision, the taxpayer has recourse through the federal judicial system, the federal judiciary. The federal judiciary is a two-tiered system. It's comprised of trial courts and appellate courts. Now, to be fair, there are two levels of appellate court, the Supreme Court and the other appellate courts. But essentially, they're part and parcel, or kind and kindred spirits, so they're considered the same level. The trial courts, basically the ball gets rolling. The taxpayer seeks redress through one of four venues. The small case division of the tax court, the tax court itself, the U.S. District Court system, or the Court of Federal Claims. Now, I'm going to go into an overlay of the federal judiciary here. This might seem a little complex. It's really not. But you've got 13 district courts. You've got 12 regional districts. Basically, the United States and its territories are divided into 12 regional districts. And those districts hear cases, of all kinds. Okay, legal, criminal, civil, tax, non-tax. They may be jury trials. They may be single judge trials. But that 13th court, the Court of Federal Claims, that court only hears issues arising from conflicts or disputes with the Constitution, executive agency law, federal regulations, federal law, that kind of thing. It only hears issues or disputes arising from the federal government. Okay, some kind of contention with the federal government. Okay, so you would never hear a kidnapping case there. You would never hear a counterfeiting case, or businessman A from Florida suing businessman B from another state. You would never see that kind of an issue resolved in the Court of Federal Claims. But it is a venue for a taxpayer, because a taxpayer generally has a dispute with a tax law or an agency. Okay, now going back to small case division, I honestly don't know if the small case division is considered a regional or a nationwide court. I think it's considered a nationwide court. What I do know is that it has its judges. I don't know much about the judges now that I think about it. The small case division only hears cases involving sums of $50,000 or less. The taxpayer does not have to pay any deficiency before his case or her case is heard. It's an informal setting. Decisions rendered, which are known as summary opinions, carry no precedent. So if I'm going into court with a similar case, I can't refer to a judgment in the small case division as a precedent. It's got no precedential value. And here's the thing that's really hairy. Those decisions are not appealable. Okay, you can't go to an appellate court if you don't like the end result. And there's one other thing. Not appealable. I can't remember. Oh, yes. The IRS has a higher win rate in small case claims, in the small case division of the tax court than in any other venue. And it's theorized that the reason why is because the dollar values involved are less than $50,000. Most claimants or most plaintiffs, it's not worth retaining the services of a qualified legal representative. So most plaintiffs are representing themselves and they lack the legal expertise to do themselves justice. Now, another venue in which a taxpayer may seek redress is the tax court. And the tax court is considered, because most of its judges, and there are 16 of them, is it 19? Yeah, there are 19 of them. There are 19 judges, and this is considered a nationwide court also, even though the judges travel throughout the United States. Okay, but it's considered a nationwide court. The judges, the 19 judges that travel, they are generally former Treasury Department or IRS officials, so their judgments tend to be pretty sharp. The tax court decisions, well, the tax court judges tend to be considered subject matter experts in the area of tax issues and disputes. And that may be a good thing, it may be a bad thing for the person seeking redress. We'll talk about that in a minute. Again, in tax court, just like in the case of the small case division, the litigant, the plaintiff, does not have to pay any deficiency beforehand. However, unlike the small case division, decisions rendered in the tax court are appealable. Now, where they're appealed to is to the court of the appellate court of jurisdictional authority. So what does that mean? Okay, remember I said that the U.S. district court system, the United States and its territories, were split up into 12 different districts. Okay, what that means is, let's say I'm from Virginia. I know for a fact that the 4th district is comprised of the Commonwealth of Virginia and the states of North and South Carolina. Okay. So if I went to tax court, someone from Washington, D.C. would travel down, presumably to Richmond. They would hear my case, and if they rendered a decision that I felt was unfair, or which I took issue with, then I would have redress through the 4th Circuit's appellate court. Okay, the Court of Appeals for the 4th Circuit, which is also down in Richmond. Okay. If I had been in California, we would have gone through the 9th. Okay. I think down here in Houston, we're in the 5th. Okay. So I would have sought redress at the appellate level through the Court of Appeals for the 5th Circuit. What else do we need to know about the tax court? That's pretty much it. Okay, another venue is the U.S. District Court, the Regional District Court. Now, the problem with that, it's a regional court. And the judges tend not to have, they're sort of jacks of all trade. The U.S. District Court is hearing criminal cases and civil cases. It's hearing tax cases and non-tax cases. You might have in the courtroom next to you a trial regarding counterfeiting. The one next to that could be kidnapping, interstate kidnapping, or drug dealing. Okay, so the judges there tend not to be subject matter experts. They tend to be more generalists. What else? you do have to pay the deficiency here. The taxpayer does have to pay any deficiency before the case is heard. Now, you can have a jury trial, but I want you to understand most tax-related disputes arise from an interpretation of tax law. Jury trials deal with questions of fact, not law. Okay, so it's going to be a rare situation where you have a tax-related dispute and you're going before a jury. Jury trials, as I said, juries deal with ascertaining questions of fact, not questions of law. Okay, so you're probably going to go in front of a judge, a single judge. Now, you also, the fourth venue of recourse is the Court of Federal Claims. Let's see. And the Court of Federal Claims is a very viable venue if you need a pro-business decision, or if you have an equity decision. And I don't know why that is, but it has a history of being very pro-business, pro-equity. Now, they've got 16 judges, but as I said, they only hear cases involving disputes with the Constitution, tax treaties, or treaties enacted by Congress, agency law, or federal judiciary decisions and interpretations. Okay. Okay, and again, you have to pay your any deficiency before your case is heard, just as is the case with the district court system. Now, that's the trial court system. Above that, you've got the appellate court system. Okay, and again, the Court of Federal Claims has its own separate Court of Appeals. Each district court has its own Court of Appeals. Now, I'm going to go and talk about that for a second. It's something I should have talked about earlier. There are 94 district courts throughout the United States and its territories. Now, as I mentioned earlier, there were 12 district courts, so that kind of gives you an idea. They're on average like 7.8 district courts per district. Now, in Virginia, in the 4th District Court, which involves Virginia, which is comprised of Virginia and the Carolinas, there are 7 district courts. Okay. A decision rendered in each one of those district courts within that district is binding, has precedential value on the other courts in that district, but that is all. They are not binding on cases being heard in other districts. They can be introduced. They carry a certain amount of value, I agree, but they are not binding. Another district court in another district may disregard, may dismiss the finding or decision of a district court in the 4th. Now, as I mentioned earlier, every district court has its own appellate court. So there are 13 appellate courts, 12 for the 12 regional districts, 1 for the Court of Federal Claims. There's also a Supreme Court, so technically there are 14 appellate courts. But what I'm getting at is an appellate court decision, let's say in the 4th Circuit, is binding upon all 7 of the district courts within the 4th, and that is all. It does not influence another appellate court in another region or their subordinate district courts. A Supreme Court decision, on the other hand, does affect everybody, both at the appellate level and at the trial court level. Okay? An appellate court is generally a 3-judge panel. They concern themselves with matters of law, not matters of fact. Okay, that's the prerogative, the domain, or the purview of the trial court. Trial courts hear evidence, or they receive evidence, they hear testimony, and they compile a court record. The appellate court does not take new testimony. It does not admit new evidence. It restricts itself almost exclusively to a review of the court record as compiled by the trial court, and it seeks to ascertain whether or not the law was correctly applied and whether or not it was the correct law. It does not review, generally speaking, an appellate court does not take issue with a trial court's fact-finding results. Okay. The appellate court can either affirm a trial court's decision, it can reverse it, or it can remand the case back to the trial court for further consideration. And if it's a complex enough case, it may involve any combination of the aforementioned. What else? Okay, the judicial decisions that come out of the tax court. We're going back to the trial court now, back to tax court. I forgot to mention this. Remember, the small case division of the tax court is a subordinate unit of the tax court. It issues summary opinions. Is that correct? Summary opinion? Summary decisions. Those decisions have no precedential value and they are not appealable. Okay? But at the tax court level, the tax court issues regular decisions and memorandum decisions. Now, a regular decision is rendered when the tax court is hearing a case that's novel. Okay? It may issue a memorandum decision when the case being heard involves previously established concepts of legal principles. And while we're talking about the tax court, I want to talk about something that's very important. It's called the Golson Rule. Up until about 10 years ago, maybe 15 years ago, the tax court rendered decisions that it felt were just. Right. Shouldn't that be how isn't that how it should be? However, but with the advent of the Golson Rule, the tax court now only renders its own opinion in a case when the appellate court of jurisdictional authority has either never heard a case of similar characteristics before, or if it has rendered a decision consistent with the tax court's position. What I'm saying is, a case comes in front of the tax court. Again, let's put us back in Virginia. I've gone to the tax court. I'm a Virginia resident. I've gone to the tax court to take issue with, say, a Treasury regulation. The tax court will look to the appellate court of jurisdictional authority, which is the Court of Appeals for the 4th District in Richmond, and say, hey, have you guys ever rendered a decision in a similar case like this? And if the appellate court goes, yeah, the tax court will say, well, what was your decision in that? Now, let's say for the sake of argument, the appellate court's decision was we found for the taxpayer, which was contrary to the tax court. The tax court would say, okay, we don't like that decision, but we'll abide by it. And so they will find for the taxpayer. What I'm getting at is shop your venue carefully. Okay. Let's say, again, I'm a Virginia resident. I've got a tax dispute with the Treasury. I'm going to go, before I even introduce that case to the 4th District's tax court, I'm going to go to the Court of Appeals. And I'm going to say, hey, Have you guys rendered a decision in a similar case like this before? And if they have, I want to find out. I want to know: did you move favorably for the taxpayer or not? And if they rendered a decision disfavorable or unfavorable to me, then I'm going to say, okay, let's not introduce the case there. Okay, I'm going to look at the other regional Court of Appeals decisions. Who knows, maybe out in California, maybe out in the Ninth. 1954, the appellate court in Sacramento found in favor, a similar case found in favor for the taxpayer. I'm going to try and get my case introduced into the Ninth Circuit. Now, I don't know how to go about doing that. Maybe I've got to move there and establish residence for a couple of years. I don't know. But what I'm talking about, the Golson Rule, what's implied in the Golson Rule is shop your case. I should say shop your venue. Okay. At the end of chapter 1, we talk about tax planning. Tax planning basically says, 1, avoid taxable income. And if you can't avoid it, defer it as long as possible. And that's consistent, by the way, with the wherewithal to pay concept. Remember we talked about later, where you might have benefited from a realized gain in a transaction, but you don't actually recognize anything until when you dispose of the asset that you've received. Now, if you can't avoid, if you can't defer, then you convert. You try to convert the income into something that's more tax friendly. So if you're an individual, you try to convert taxable income from ordinary income to capital gains income. Ordinary income is taxed, for an individual, is taxed at the rates of 10, 15, 25, 28, 33, 35, and 39.6%. Capital gains for an individual are taxed at 15 or 20%. Chances are, whatever capital gains you derive from a transaction, if you can get that transaction considered as a capital gain, you're going to probably, as an individual, wind up paying less taxes. Now, I want to point out, all of that is not applicable for a corporation. Corporations don't have preferential capital gains tax rates. If you're a corporation and you sell a piece of property and you derive a capital gain, that capital gain is considered ordinary income, and it's taxed at ordinary corporate income rates. Okay? And that's chapter 1. Thank you for watching.